On this episode of Law Weekly, we talk about the performance of the judiciary under the outgoing administration of President Muhammadu Buhari, agenda setting for the president-elect, and even the distrust that some people have expressed about the proceedings of the Presidential Election Petition Tribunal. We have the views of a senior advocate of Nigeria, Boma Ayomide Alabi. Also showing on the program, highlights from the Valedictory court session of Justice Oludotun Adefope-Okoje as she retires from the Court of Appeal after clocking the mandatory retirement age of 70. Plus a recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. Let's begin at the Presidential Election Petition Tribunal, whose proceedings everyone is watching with a lot of anticipation, emotions, and even expectations. My guest, Senior Advocate of Nigeria, Boma Alabi, is no stranger to election petitions. She's participated in some high-profile ones and understands the mix of emotions and anticipation they attract. Boma is also an experienced arbitrator and accredited civil and commercial mediator with experience in diverse fields of law spanning over 30 years. She served as the president of the Commonwealth Lawyers Association from 2011 to 2013, the first woman president in the over 50-year history of the Association of Lawyers from 54 countries. A cross-border solicitor and officer of the Order of the Niger OON, Boma was elevated to the rank of Senior Advocate of Nigeria in 2020. I began with observations of the proceedings of the tribunal, and she says she's confident that the court will do justice in all the petitions filed before it.
Well, I was part of the team in 2019, and so I've had the first-hand experience of what goes on there. There's a lot of pressure, like you rightly said, a lot of interest by the media and the citizens and perhaps even the international community. They are under a lot of pressure because of the timelines. There are a large number of lawyers involved. Usually the courtroom cannot even contain the lawyers, not to talk of the others. But, certain. They've settled pleadings. We've seen all the pleadings. The two leading parties have filed. Others have also filed. One or two have withdrawn. This is the usual sort of thing that happens every 4 years. I have to say, though, that in 2019, there were far fewer petitions, and I'm not just talking about presidential, across the board, than there have been this year, which tends to indicate that a lot more people are dissatisfied with the conduct of the elections this year than they were the last round.
There are a lot of emotions and expectations from the proceedings of the Presidential Election Petition Tribunals. And some people have been, expressing this view that it would be same of the same. We're not likely to get any justice, from this tribunal, especially when they reference the fact that we've not seen any presidential elections upturned in recent times in the country. So much so that some have even made a case that the petitions should be concluded before the swearing in of the president-elect, just because of the distrust that some have for the sitting of the tribunal. As a senior legal practitioner, one who goes to the court every now and again and who believes in the process, what would be your message for people who think like this? And what do you think that the court itself can do to engender confidence and trust in its system?
You see, previously, before the enactment of this new Electoral Act, the bar was extremely high. The the petitioners, absolutely almost 100% unlikely to win because of the way the law was at the time. The sort of evidence they had to bring and the timeline within which they had to bring it was an uphill task. Now, with this new act, it is slightly different. ANEC can be compelled and was compelled to bring forward the evidence that is required by the other side. Also, There are aspects of the new act that talk about the qualification of individuals, which previously was pre-election only. I think also if our courts are, let me use the word, courageous enough to depart from their established jurisprudence, which after all was established around the old law. This is a new beginning, and you should have the courage to look at this new law and interpret in accordance with it. If it's not in line with what you've done in the past, it's quite all right. So, and I do believe that the judiciary generally are courageous. Some can be conservative, but generally they would look at it, and hopefully if it requires new interpretations in line with the new law, then so be it. What the public may not know is the court cannot consider information that is not before it. It will have to make a decision on the pleadings, what has been put before it. So for instance, in the media, there's been a lot of speculation about one of the candidates having a dual citizenship and so on and so on. That is not before the court. And the lawyers and all of us owe it to the courts to help our citizens understand that not every issue that is in the media is before the court, and therefore they cannot adjudicate on issues that are not before them.
The call for live telecast of the proceedings, ostensibly for transparency and for more people to be able to follow the process. What do you make of that call?
I am for it. I aligned myself with the NBA president, who was one of the first to advocate for this. You see in the recent trial of the Ekweremados in the United Kingdom, the trial was televised, and certainly the judgment, which has literally gone viral. And I don't see why, if it's an open court, which it is, and the media are allowed to be there to record, why can't they record it electronically? It's just a question of accepting the modern and additional ways of communicating and getting information. We are doing virtual trials via Zoom and other platforms. I really do not see why we cannot have the trial televised. It will enhance public enlightenment and also the confidence in the judiciary, because they can then see for themselves how the court is comporting itself, hear for themselves what the court is saying, not through a third party.
But some people say that if you allow the cameras in, then some of the lawyers will play to the gallery.
They play to the gallery anyway, and they act for the public. And as a matter of fact, it could have the reverse effect, because when you do all of that playing to the gallery and you're publicly told off by the court, you'll be more circumspect next time around, because it will not just be in the closed courtroom, it will be out there.
Let's talk about this administration, or the government of President Buhari, and as it winds down. How well would you say that in the 8 years that they've been in office, they've allowed the judiciary to thrive and to be? How well would you say that the judiciary has fared under this present government?
I have to say that we achieved a new low under this administration in relation to treating the judiciary with mutual respect as an equal arm of government to the executive and the legislature. It is in the past 8 years, I certainly haven't witnessed this before, that we are having judges' homes being raided at night by security agencies. judges' homes being raided by supposed security agencies that weren't quite security agencies, and nobody quite knows who they are. It is under this administration that we had this sitting Chief Justice of the Federation effectively removed by, and it's simply a new law. It is the third arm of government, or certainly an arm of government, of equal positioning as the executive and the legislature should be treated as such. So that respect that should be accorded to the judiciary was largely impinged upon in this period. I hope that the next administration and these security agencies will learn to behave better. Nobody says you can't do your work. Nobody says anybody is above the law. I would be the first to say nobody is above the law. But you have to approach things in a way that you do not, in the process, harm the institution. Because this really is the last bastion of the common man and civilization. Take the rule of law out of any society and you end up in a jungle.
And as part of agenda setting for the incoming administration, apart from the issues of welfare of the judiciary, which we've already talked about, what more do you think that the incoming administration can do to improve, the standards of the judiciary?
Well, number one for me is the remuneration. We've talked about that. Benefits and compensation when they exit. So, for instance, the Chief Justice of the Federation, on exit, will be given a house and various other benefits. As far as I'm concerned, and this is the fact, the Chief Justice is the first amongst equals. They're all justices of the Supreme Court. And every justice of the Supreme Court should have the same benefit. When you exit, you get a home. Even before you exit, some of the states are doing that. As you're appointed, you're given a home. You know that you don't have to worry about where you're going to retire to. You know that you have a roof over your head when you retire. These are essential minimum benefits. Look at the chief executive of state and the humongous pensions that they give themselves. One public servant as the governor of a state, and then judges and justices who give so much more time, years, with all the occupational hazards that they suffer. And at the end of the day, you go home and you don't have a home. It's not acceptable. That should be remedied at federal level as soon as possible. And also the pay. Even though, yes, there's been an increase, it's still abysmal.
Apart from the issues of welfare of judges and financial independence, because I know that you're big on those issues, what about the issue of technology and the courts? I mean, during COVID, we had virtual sittings, we had Zoom hearings. How well have we continued, to make use of those technology? And how well would you say that the judiciary has fared with the use of technology? Have we even kept up?
We have. I mean, this year alone, I have at least, I think, 5 or 6 virtual hearings, trials that we conducted virtually. I think our colleagues really are the ones who are trying to pull us back. Because invariably, when you make an application for a virtual hearing, they invariably oppose. And again, this is one of the things we do here that I really feel is below par as professionals. We waste the time of the court with this opposing this, wanting to effectively stop justice from being done by putting stumbling blocks and impediments, bottlenecks in the way. In England, no judge, the court will not tolerate that from you. And you will have to remember your duty is to the court first, before even to your client. The technology is here, it works perfectly, and we can even use the device as small as your handset in order to do this. From the perspective of the state, funding the infrastructure to enable that virtual hearing is one of the things they should make a priority. So the internet connectivity has to be very good. There has to be a backup. There should be a large screen in each courtroom, because right now we're all on our laptops, so that the public gallery can also observe if they wish to.
Welcome back. A legal icon, a hard-working jurist who has established a reputation for being fair-minded, courteous, and outstanding. These are just a few adjectives that have been used to describe Justice Oludotun Adefope-Okoje on the occasion of her 70th birthday and her retirement from the Nigerian judiciary. She served the judiciary for 27 years and the last 9 of those years at the Court of Appeal. So it was befitting for that court to honor her with a valedictory court session to mark her exit from the bench. Here are some of the highlights from that session.
Gathered here in this courtroom of the Court of Appeal, Lagos Division, are members of the executive, legislature, and of course, the judiciary. Is the valedictory court session organized by the Court of Appeal to honor Justice Oludotun Adefope-Okoje following her meritorious service to the bench. The President of the Court of Appeal, Justice Monica Dongban-Mensem, is represented here by the Presiding Justice of the Lagos Division, and in a speech he read on her behalf, Justice Dongban-Mensem described the valedictorian, among other things, as an admirable jurist with a stellar career on the bench.
Honorable Justice O.A. Adefope-Okoje has established a reputation as a hard-working, fair-minded, courteous jurist who has made outstanding contributions to our legal system and the administration of justice.
Other senior lawyers also took turns to x-ray the valedictorian's legal career of over 4 decades.
At the Court of Appeal, my Lord is leaving a footprint of courage and fairness. With the same vigor that my Lord dissected life legal issues was the same way my Lord contributed to our legal jurisprudence. In her Lordship's book, Civil Litigation, a quick reference, is one of the ways that her Lordship has put out her experience in print, in addition to her Lordship's judgment.
I am pleased to say that Honorable Justice Oludotun Adefope-Okoje, JCA, has a positive, impactful, and honorable legacy. My Lord's career spanned different aspects of the law, from litigation to corporate law, in the Ministry of Justice, as an employee in a law firm, and eventually as the proprietor of a law firm.
We note that you are retired, but you're certainly not tired. You are retired only from your position as a judicial officer within the Federal Republic of Nigeria. We believe that actually you are retired, as in R-E-T-Y-R-E-D. That is, you'll be putting on new tires for new directions. We wish your ladyship well, and we look forward to meeting you in other aspects of legal practice.
The governor of Ogun State, Governor Dapo Abiodun, says the state is proud of the contributions of this brilliant jurist.
My Lord, from all accounts, is a very upright woman, a very forthright jurist, who discharged her duties with courage and integrity. She, at the same time, willingly mentored a lot of young and aspiring lawyers. And this in itself is very noteworthy. We want to thank you Lord, for being a good ambassador of the Gateway State.
In her valedictory speech, Justice Adefokpe Okoje went down memory lane, recalling her time at the bar and the bench. She also spoke about some of the reforms she would like to see in the judiciary.
Now, I cannot end my address without expressing my pains and that of the general public on the pace of justice delivery in the court. If the truth be told, our pace of justice delivery is in total paralysis. It is not acceptable that a case averagely takes more than 5 years to conclude a trial, more than 3 years minimum in the Court of Appeal, and averagely about 12 years in the Supreme Court, given a conservative figure. A country that seeks foreign investment must get its court system functional, accelerated, and receptive to the needs of the people, both domestic and international. No nation wants to invest in a country where judicial disputes take forever to conclude or at all. Almost every case goes to the appeal court and the Supreme Court. This should not be. There is no reason why motions for injunctions, stay of proceedings, landlord and tenant should go beyond the high courts. The NBA is charged, in conjunction with meeting with the bench, to determine this issue expeditiously. Please don't kill our judges. Don't kill the justices. And with a view to working with the National Assembly for amendment of the laws to this effect.
Justice Adefokpe Okoje, a celebrated author, was called to the bar in 1976. She served at the Ministry of Justice, Jos, Plateau State, before venturing into private legal practice. After 20 years, she joined the bench in 1996 when she was appointed a judge of the High Court of Lagos.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtrooms.
We begin at the Presidential Election Petition Tribunal. The five-man panel has fixed May 22nd for the ruling of the application by Labour Party for live coverage of its proceedings. The panel also adjourned to May 20th for parties to agree on the schedule of hearing in the main petition. Beginning with the petition of the People's Democratic Party and its candidate, the respondents have filed 7 applications asking the court to strike out their petition. The lead counsel for the PDP, Chris Uche, also accused INEC of being partial by taking up the defense of the president-elect, contrary to the provisions of the law. He insists INEC ought to be neutral. Candidate of the PDP, Atiku Abubakar, on his part, is accusing INEC of being a proxy in its petition against Bola Tinubu's qualifications for the election. INEC has said the allegations, which formed 32 paragraphs in Atiku's petition, should be removed by the court for various reasons, including lack of jurisdiction. In Kano, a federal high court sitting in the state has held that the failure of Labour Party to submit its register of members in Kano and Abia State is in gross breach of the provisions of Section 77, subsection 3 of the Electoral Act 2022, and the purported elections of the Independent National Electoral Commission, INEC, is invalid, null, void, and of no effect. The court also held the fundamentally flawed elections of INEC as a result of the failure to comply cannot produce a qualified candidate that participated in the general elections for all the elective positions in Kano and Abia State. Justice Mohammed Yunusa also held that INEC was bound to insist on receiving the register of members of the Labour Party and that of other political parties in both soft and hard copies in all the states at least 30 days before it can conduct its elections for its candidates that participated in the elections. The court made these findings in the suit filed by one Ibrahim Haruna against the Labour Party and INEC. The court held that the votes cast for all the candidates of the Labour Party in Abia and Kano states in the elections are wasted votes, and as they are not parties before the court, it lacks the jurisdiction to make an order for the issuance of certificate of return to them. Staying with Labour Party, Justice Hamza Muazu of a High Court in Abuja has granted an order of stay of execution on the suspension of the chairman of the Labour Party, Julius Abure, and others. Other officers affected are the National Organizing Secretary, Mr. Clement Ojukwu, and National Treasurer, Oluchi Okpara. The plaintiffs in the case had in an ex parte motion sought the removal of Abure and the 3 other national officers of the party. After listening to arguments from the parties, the judge granted the order for stay of execution pending the determination of the appeal filed by the defendants. And we round up with the report that a Lagos Chief Magistrate Court sitting at the Sabo area of Yaba has ordered the remand of Afrobeat singer Seun Kuti for another 4 days in police custody over alleged assault on a police officer. Chief Magistrate Adeola Olatubosun ordered his continued remand sequel to a motion ex parte brought by the police seeking for an order of the court to further remand the defendants at the State Criminal Investigation Department, Yaba, Lagos, to enable them carry out further investigations. Seun Kuti's lawyer, Senior Advocate of Nigeria, Adeyinka Olumide Ofushika, had faulted the procedure adopted by the police in seeking a further remand of his client.
And that's the program for today. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shele. Thank you for watching and see you next week.